Once again, welcome everyone. Thank you for joining us for today's webinar. I am Divya from Relativity Management Solutions India Private Limited. I would like to introduce today's presenter, Mr. Akash. He is a successful young entrepreneur, speaker, innovator, and payroll expert who helps business leaders. He is the director at Relativity and he is well known as a financial specialist for over 13 years now. He has conducted more than 250 sessions offline and online, as well as Relativity's regular webinars every month. He is the host of Relativity Knowledge Series, a young YouTube channel to help HR professionals be better, and the lead author of our Relativity's blog. It's time to start our webinar. Let's start, and over to you, sir. Thank you.
Divya, as always, thank you very much for that quick introduction. And I hope I'm audible to all of you. Say yes on the chat. Happy to know that. Okay, wonderful. Thank you. This particular second Wednesday of every month is so very exciting because this gives us an opportunity to add value to all of you. How do we add value? We add value by bringing very, very useful information, which sometimes, or most of the times rather, is in the areas of payroll, taxation, compliance, and accounting, in terms of updates, in terms of industry best practices, so on and so forth. And I think we've been doing this for about 7-8 months now. Every Wednesday. Earlier we had webinars which were not scheduled, but from the last 7 to 8 months, we have webinars every Wednesday, second Wednesday of the month. And there has been so much of value that we have been able to provide. We get a lot of good feedback from all of the participants. A lot of participants reach out to us subsequently and tell us how it has helped them in their professional career or even at their organization, at their job, so on and so forth. So, it's really nice to see you all. I'm very excited, obviously, to be here. And from the last 2-3 sessions, we have been, trying to try out this. We have been trying to try out this new concept of crowdsourcing. Crowdsourcing is where instead of we telling what should be the topic or we talking about a specific topic, we want you guys, the HR professionals, business owners, financial professionals from various different industries, from various different geographies, to tell us what would you like to know, right? And then we've been getting some very, very unique ideas. Thank you for all of you who have been contributing to our crowdsourcing question. And I request, those who have not contributed until now, when Divya, the person who spoke a couple of minutes ago, when she sends out an email, probably 1 week before, the schedule, I would request all of you to key in your, thoughts, your comments, your questions in terms of, okay, this is what I would like to hear. Or probably if we come out with a list, I request all of you to vote for what you'd like to hear. And that would be something very, very exciting to do. So this time of this time of the webinar, we are talking about a very, it's not a sensitive topic, but it is not insensitive as well. It is very, very important for business. It is very important for all the HR, finance, and business owners, you folks who are there on today's webinar, is specifically in terms of legalities, right, regarding offer letter, appointment order, and its validity. And we are going to specifically talk about 2-3 legalities because we have only 40 minutes. So I'm not going to take a lot of time. 40 minutes, we'll try to cover as many legalities as possible, 2 or 3 in my sense, and then we'll have about 15 to 20 minutes open for questions today because this is a very, very subjective topic, and I'm sure there is a lot of subjective questions that you will have with respect to something that you have come across, or probably some kind of unique situation that you have in your in your organization or in your industry that you represent. So is this good? If yes, say yes on the chat, and then do have your fingers on the chat as well, because this is not just going to be a presentation. It is going to be something where we're going to exchange ideas, your interaction with us, and all of that. Wonderful. Thank you very much. Thank you very much for all of those who have said yes. So let me begin with this one question, right? I see, we have participants from LinkedIn, live feed. We have participants from YouTube also. So shout out to all of you guys who are there on our Zoom, who are there on our LinkedIn, who are there on our YouTube. Let's begin with this question number one. Can an employee work for multiple employers simultaneously? Just don't say yes or no. You should also be ready to give an explanation. If you say yes, why yes, and if you say no, why no? Let's see what the chat comes up. So the question is very simple. Can an employee work for multiple employers simultaneously? So the question, yes, no, yeah. But why do you think no, an employee cannot work? Or why do you think yes, an employee can work? I think that bit of explanation is important. Okay, I see quite a lot of no's and yes, and then there is one gentleman, one gentle lady who said yes if they work part-time. Okay, employee can work in full-time in a company and as a freelancer in multiple companies. Okay, because his PG contribution cannot be twice. What is PG? I think you are meaning PF, Ashish, if I'm right. Can't. Yeah. Okay. Yes, because the labor law does not state anything about multiple employability. Absolutely. There is a moonlighting policy now. Okay. And Kayuri, would you like to explain what it is? Conflict of competition may arise. Wonderful. So let me clarify. There is no act, there is no law which states that employee cannot work for multiple employers. There is absolutely no law at all, right? We'll see some conditions as well. It's not that it's absolutely no, and it's not that it's absolutely yes. So there are some conditions. Working within the same industry or trade, right? We have to invoke the non-compete clause. Working within the same industry or trade, we have to invoke the non-compete clause. Working outside the same industry, sorry, there is a typo. Working outside the same industry or trade, we have to invoke the office of profit, right? So you all know, right? As Indian citizens, we have the right to practice any trade, any profession that we want. That there is no restriction in any of the law restricting us from practicing only one trade. Let's say if you are a HR professional for XYZ company, there is nothing restricting you from being a HR professional for ABC company. We are payroll professionals. Payroll is in our blood. We are number nerds, relativity guys. So there is really nothing that stops relativity guys from practicing their profession elsewhere, unless and until relativity and the employer and the employee have a TNC, terms and conditions, signed that they will not, right? And that clause is called as the non-compete clause. Non-compete clause during employment, if this is not signed, you can really not question anybody about why they are doing, whatever they're doing. They could be a freelancer, they could be, driving an Uber and Ola, yet working for you full time, does not matter. But as long as you don't sign a non-compete for working within the same industry or trade, you really cannot enforce anything out of law. Now, what about, working outside the same industry or trade? What about working outside the same industry or trade? That is what we call as office of profit, right? Like, for example, there are some examples that I would like to give you. We all know there were today MLM has become outdated, but there was a time, early 90s, early 2000s, when MLM was the top of the top. Every third person that you would meet would have been in some MLM or the other. Herbalife, Amway, Modi Care. There were just so many. And even today, MLM companies exist, MLM opportunities exist, and even today people practice MLM. This is actually not employment, but rather office of profit, right? Are you prohibiting your employees from holding another office of profit? If yes, where is it being included is something that you have to think about. If you don't want your employees to practice, usually, though there is a clause in the appointment order, usually office of profit is a clause that has to be included in both your offer letter as well as appointment order, prohibiting the employee from taking any office of profit status, right? But then we've just there are just so many examples out there. People who are doing some kind of MLM business, people who are an insurance agent, LIC or any other insurance company, or some of the more advanced ways of office of profit are when somebody is also an author on about a book, right? They have written a book and they are an author. Although the percentage is very small, but that is also another office of profit example. What about when your team, when that particular employee goes and talks at a seminar and is paid? That is also an office of profit situation. So until and unless we have the non-compete clause during employment and the prohibition of office of profit clause during employment, you really cannot stop anybody from, or you cannot even forget stop. You cannot even question anybody from taking office of example. Yeah, so that is something which is very, very important. And many times, employers are agreed that this is what is happening. This fellow is working with me or with this company in the morning, and then he goes on and he works as a freelance software developer or for some other trade in the later hours of the evening, which is affecting the productivity of the employee at the main important work. But the real question is, do we have these two clauses included in our offer letter as well as in our appointment order, right? Offer letter you have to include because the employee needs to know what he's getting into, what are the terms and conditions of the employment. That is what the offer letter stipulates. And why in the appointment order is because that is the acceptance that the employee provides. The employer and the employee both agree on the fact that I will follow these terms and conditions. You will follow these terms and conditions, which are stipulated on the appointment order. Typically, office of profit, if we don't have the ability to include all of the policies in your appointment order, you should at least have a separate HR policy mentioning what is considered as office of profit, what is allowed as office of profit. You really can't stop anybody from going and talking at a seminar and getting paid, right? That would be even in fact a counter interactive. That would not be a great idea. So what people usually do is what companies usually do is they request the employee to get consent before going and talking at these kind of seminars where they are paid. Even if they are not paid, it's okay, but still get the employer's consent. If you are talking about something that is specific to your employer, not only consent, but also approval that you are disclosing this information, which exclusively belongs to the employer. So there is also this clause which has to be written down in the office of profit. Otherwise you really can't stop anybody from doing what they want. Yes, there is a non-confidentiality agreement, I mean confidentiality agreement or a non-disclosure agreement separately in place, but that is not very specific to cover office of profit examples, right? Look at educational institutions. You have people who author books in educational institutions, in universities. So what they usually do is the university, they get consent from the university that, I'm authoring this book in this particular area, and that is what I'm going to do. Somebody who, if I don't know if you're aware, but even those who are independent directors and senior employees can be independent directors at other companies if they wish to be that. And if that is the case, then they have to inform to their employer that this is the company where I'm considering. If it is a competitor, then the test of conflict has to be resolved before they take up that position. But all of this has to be governed in your organization's HR policies under the heading office of profit or under the heading non-compete. In addition to that, we also need to have these clauses specifically stated out both in our appointment letter as well as in our appointment order. Only then you can actually prohibit somebody, or to that extent you can stop somebody from doing something which is against the company, right? So that's very important. I think there are a couple of questions. Is it okay if I take the questions later? I hope that should be fine, because so that we finish off within the first 40 minutes, and I will definitely take questions later. Now, how many of you have non-compete agreements or non-compete clause in your offer letter and appointment order? How many of you have non-compete agreements and non-compete clauses in your appointment order and offer letter? Say yes if you have, and say no if you don't have. There are approximately about 100 participants, so I'm sure what are the gap clauses in appointment letter? Okay, yeah, we'll definitely take that up, Rajesh. But there are a couple of responses I'm receiving. Yes, most of, at least until now, most of it is yes, but I see a few no's as well. So the question is, do you have a non-compete clause in your offer letters and appointment orders or appointment order? In any of those, do you have a non-compete clause? Okay, so there are very few who have said yes, and quite a lot who say no. So the question to you guys is, do you really want to know about the legality of non-compete clause? Because a lot of you don't have. So I don't know if this is going to be useful to you. But if you think we should continue talking about the legality and the nitty-gritties of non-compete clause, we can do that, or we can even skip and go to the next section. What do you guys think? It's an exciting morning, right? Wherever you are, in whichever part of India or the world you are, it's an exciting morning. So let's show that on our fingers. Okay, so there are at least whoever have responded, you have said okay, you would like to know. Wonderful, thank you. We'll continue on the non-compete agreements in that case. So what do you mean by non-compete, right? First, let's try and understand what it is. Is it only that I should not go and join another competitor? Does it mean that? No, it actually doesn't mean that alone. There are non-compete, comes out in many different ways. Some of them are written down here. Restriction to engage with competitors in any capacity. Let's say you are running a manufacturing company, and another manufacturing company becomes your competitor, right? In the same industry, manufacturing the same products or services. I mean, products or goods. Then that particular organization becomes your competitor. So restrictions to engage with competitors, restrictions in operating your own business in a similar industry. That's also something important. Let's say you work with some organization for 10-15 years. You've got to learn, you've got to know the trade secrets, you've got to know their modus operandi, you've got to know the business model, you've also developed good relationships with their clientele, and all you do is just open another shop next door or probably a few doors away, and then you start your own business. Does that amount to non-compete? That's also one of the things in non-compete. Restrictions to solicit or engage employers' resources and consultants or approach employers' clients, right? So I'm working with you, but I take after I move out, I take away your suppliers, which may be your key suppliers. I take away your key employees, which is poaching in some way, solicit, right? Or I take away some of your key clients, or even if not key clients, general clients. Then that restriction is also a part of non-compete. And restriction on working in the same geographical location, right? So you would have seen this exclusivity usually with some dealers of some sort, like for example, automotive dealers. You don't have automotive dealers like 10 and 15 dealers of the same brand in one city, right? There is some kind of restriction that the automotive companies talk about, with the automotive dealers. So there is max to max about 2 or 3, depending on the size of the city, depending on the geographical area of the city. It is usually predetermined by the automotive company, and restrictions on those aspects is also a part of non-compete. So non-compete, we shouldn't narrow it down to only not joining another employer. That's not non-compete alone. There are a lot of things in way non-compete can be interpreted, and let's see some interesting aspects about non-compete. So recently I remember Infosys. I'm sure you also would have read that Infosys had this non-compete clause in their newly rolled out offer letters or appointment orders, and prohibiting employees from joining competing companies for a period of 6 months, which was very seriously taken up by the Ministry of Labor, and then a show cause notice was sent out. But ultimately, so whatever I'm telling is not private information at all. It's public information. It's available in the public domain. So I'm not breaking any laws here. And Infosys did not attend to the show cause hearing. I think even until now, Infosys has not attended to the show cause hearing. So the question is non-compete clause on employment contracts legally binding? That's the question. Let's see what you guys think. Ajay says yes. Okay, who all are joining Ajay's team? Okay, let's split into teams. Okay, so who and all are joining Ajay's team? Who and all agree that non-compete clause is legally enforceable on employment contracts? And then whoever says no, you'll join their team. Come on. Yes. Okay. So a few more people are joining Ajay's team. Okay, Rajesh. Let's. Rajesh is no. So Rajesh's team. Who and all are joining Rajesh's team? Who says no? Employment contracts. Non-compete on employment contracts cannot be legally binding. Okay, so can we have a third answer? I don't know, because I see very few responses. So it's either yes or no, or probably you don't know. So that's another option that I can give you. It has to be either a yes or a no, or I don't know. Come on, guys. Who are going to choose Rajesh's team who says no, and Ajay's team who says yes, and then okay, got it. Vijaya's team who says not sure or I don't know. Anything of that sort? We have 98 participants and not even 9.8 people have responded. I think we should start serving some Red Bull. Good. Keep it coming. Wonderful. It's okay. It's okay if you don't know. Absolutely fine. Right? Not everybody knows everything, but that only gives me a context of how deep should I go, or how deep should I not go, depending on what you guys think. Okay, so we have quite a lot of not sure. Good. We have quite a lot of not sure. Oh wow! Now the word Red Bull itself is working. So imagine if there is a real Red Bull. The relativity team, please make a note of this. To the extent where damages to the employer can be substantiated. Yes, absolutely, Arun. You've nailed it to a great extent. But then hang on, that there are a couple of more clauses also that come into play. No, Anshul says no, since it's a guest labor law. Okay. Okay, good. So we have predominantly not sure, and then between the yes and no, we have predominantly no, and then there are a few yes. So it's good to know, right? That you know that we don't know certain things that we are talking, but if you are if you belong to the finance domain, or if you belong to the HR domain, it is so very important that you know about this. If not today, it will definitely help you tomorrow. And this is what I call as contextual knowledge of your of your industry or of your profession, right? As an HR professional, or a finance professional, or a business owner, or a leadership person, you are required to have contextual knowledge of your own practicing profession, and I'm sure today's webinar will help you do that. Okay, so there is no straight answer to this, but we'll get to the answer. So the first thing that we need to know is who says whether it is legally binding or it is not legally binding. Somebody has to tell. We are all bound by rules, regulations, laws, right? So is there a law? That's the question, right? So we have two governing laws. Let's talk about the umbrella law, which is the Constitution of India, right? Like right to speech, right? The freedom of speech, the freedom to write. All of these are constitutionally written down. You cannot change them at all. So in the Constitution of India, Article 19(1) of G says that an Indian citizen is free to practice any trade, profession, or to carry any occupation or business. There is absolutely, as long as it is legal, right? As long as it is legal, there is nothing that is going to stop you. You cannot be stopped, is what the Constitution says. So the Republic of India has given you the right to practice any trade, any profession, any occupation, any business that you desire. And that is why we become doctors, we become engineers, we become HR professionals, we become finance professionals, we become scientists, we become we get into the armed forces. It is all the choice that we have, which is given to us by the fundamental rights, which is mentioned in the Constitution of India. The second statute, the second law, which governs trade and work, is the Indian Contract Act. And Section 27 says, every agreement by which anyone is restrained from exercising a lawful profession or trade or business of any kind is to that extent void. Is to that extent void, right? So we have the Constitution, which is the mother of all the laws. Every law has to relate to the Constitution and not conflict with the Constitution. So the Constitution says that boss Akash wants to speak, he can speak. Akash wants to run a webinar, he can run a webinar. Akash wants to run a payroll processing company, he can run a payroll processing company. Rajesh wants to be a HR professional, he can be a HR professional. Arun wants to lead a company and take it to $1 billion enterprise, Arun can do that. Nothing is going to stop you. You want to become the Prime Minister of India, you can do that. You want to become the President of India, you can become, is what the Constitution of India says. And then there is another statute which is under that umbrella, which is the Indian Contract Act, because when you sign an agreement between the employee and the employer, what is happening? You are actually getting into a contract, right? You are actually getting into a contract. Have you seen terms and conditions? Tick here to proceed when you sign up on a website. When you invite somebody to join your team, there is an offer letter, or there is an appointment order, or there is a terms and conditions of the contract. That is nothing but a contract, the basis of relationship. Contract is the basis of relationship, and this contract is governed by the Indian Contract Act 1872, and in that section 27 says, every agreement by which anyone is restrained from exercising a lawful profession or trade or business of any kind to that extent is invalid, is void, is invalid. It's not acceptable. Exception being goodwill. We'll talk about the exception later. Right. So there are the mother act says you can practice anything. Nobody can stop you from doing that. And then there is this Indian Contract Act, which also says you can do anything. Nobody can stop you from doing anything, and anything which is lawfully accepted, lawful trade, if you're stopped from doing it, it's void. That is what the Indian Contract Act says, right? So then, what do we really do, right? How do we judge this non-compete? So what have the courts told? Every company has, at least it's good that you guys don't have, but a lot of companies have, simply, in Hindi we call it naam ke vaste, right? Just for the sake of it, a non-compete clause. You are required not to join a competitor for a period of 3 years after you resign from XYZ company. Is that enforceable? No, it is not enforceable. You cannot stop anybody from doing what they want to do. Even if you have a non-compete agreement signed between you and them, you can't. Until and unless there are extremely specific and extremely special situations. I will talk about it in the next few slides. So what have the courts held, right? You can see this. Every court has held that it's not enforceable. Bombay High Court and Tapas versus Cosmo Films is one of the most studied case, because at that point in time the emotions were very high. There was a lot of pressure from from the India Inc. to see if non-compete can be made viable. But then the Bombay High Court said, no, it's not enforceable after the employment period, not before, not while the employment period, after the employment period. While the employment period, it is enforceable, as long as you have mentioned it either in your, not either, both in your offer letter as well as in your appointment order. If you've not mentioned it, you cannot say you cannot join somebody else. Right? In 2006, a 2-judge bench of the Supreme Court also refused enforcement of a post-employment restriction. And in fact, this 2006 judgment, I would say, in my personal opinion, I would say it was a very, very, very strict, strictly biased judgment in favor of the employee, because this employee in question was at a very senior position, and he had all information. He was privy to all the information which was considered trade restricted information, right? Which was vital for the company to run its business. And yet the Supreme Court refused to enforce a post-employment restriction. Do you know why? Because they did not write the agreement properly. They said, had you written the agreement properly, we would have definitely enforced it. There is a case for enforcement, but because your agreement is incomplete, we cannot enforce it. Superintendent's Company of India versus Krishna Mugarai. Even their post-employment restriction is not possible. Brahmaputra Tea Company versus these people. Even there as well, post-employment restriction was not possible. And it is not only between an employee and the employer. This is the situation even between two entities working together. Right? You are a consumer, and then there is a supplier, your key supplier. You cannot stop him from really going and supplying to somebody else. You can't do that until and unless there is a very, very, very important case to it. And I think Arun is from Kobe.co. Yes, that is right. So our good friend and well-wisher Arun Kumar is also here. As he is rightly said, there are some places where we can, but it has to be clearly spelled out. There has to be a need for it, and those are what we are going to discuss in this slide. Very select industries, very select positions, and very select situations. If you have a combination of all of these three, you can actually make a case for its enforcement. But if you don't have a combination of all these three, you cannot make a situation. You cannot make an exception for their enforcement. That's not possible, right? Please look at certain specific industries. Okay, so I have a list of I have a list that I've got from my team. Before we go there, let's take a quick minute to recognize our many frequent participants. We are very glad that you are here. Ajay, Amalraj, Arun Kumar Kumareshan, of course, Jiteshwar, Manjula, Ilango, Anusha, Kubar, Navina, Poonam, Rajesh, Shruti, Somashekhar, Rahul, Sumalata, and Usha Santanu. Thank you very much. You've been our frequent flyers of our webinar. Thank you. It really means a lot for us, and I'm sure we'll welcome a lot more of the frequent flyers of our webinar to this club. With that recognition to all of you, I will come back to the point. So, what are the exceptions? What select industries? What select positions? What select situations? Let's say you are in biomedical engineering, for example. I'm just taking one random industry that just popped up in my mind, and you are testing a product which has never been there, and then you have some scientists who are working with you, yes, and their contribution, as much as their contribution is important, the employer's contribution to them is also equally valuable. So there is a win-win for both. If that is the case, then that becomes a case for an exception. Why? Because if this particular scientist is going to go and join another, let's say, a pharma manufacturing company, this scientist knows how that particular drug has been designed, has been engineered. All he has to do is go to that competitor, go to that pharma manufacturer, join there, and then start producing the drug. He has the formula. If not on the paper, he has the formula here. Right? Now you can say, okay, there is something which is called as intellectual property. Yes, there is something which is called as intellectual property. But are you putting it on paper? Is there a secrecy agreement between you and the key position, that special situation where the necessities of intellectual property have to be invoked? Then that is an exception. Let's say you are a normal Okay, let me see. Which are we on time? Okay, we have only a few minutes, so forget that. Which industry do you belong? Let's say you belong to the software development industry. Can you have a non-compete clause which you can enforce after the employee has left? If that clause is there, it's okay. It's there. Naam ke vaste, just for the sake of it. But can you really enforce? No, you cannot enforce, because it's a common industry. The fellow is coming on his own accord. You are training him for your profitability, right? And he is producing a piece of content, a piece of code, or writes a sequence which then becomes translates into a business or a business opportunity, right? That doesn't warrant a non-compete. Let's say you are a manufacturing company and you are asking your floor supervisors to sign a non-compete agreement. Will it hold? No, it won't hold, because it will fail the test of reasonableness and fairness. It will fail the test of reasonableness and fairness. So these two are one of the very key tests that all the courts take into account when, even when they come to a situation where do we do this or do we not do this? There is a gray area in the law, right? If there is a gray area in the law, the courts decide based on their subjective opinion. How is their subjective opinion decided is based on reasonableness and fairness, right? So is it really reasonable? Is it really fair? So here, let me give you a real life example. My brother, who's actually a geologist, he's a scientist. He currently works for the government of India, but right now is deputed, not government of India. He works for one of the agencies of government of India, but right now he's deputed at Norway for completing his postdoctoral research fellowship in combination with some government. Okay, so he's a geologist and a climatologist. His job required him to sign a service agreement and a non-compete agreement with a penalty of 3 crores. With a penalty of 3 crores. So his non-compete agreement is that he will not join, not a company, another country for 3 years. Okay, he cannot join another country for 3 years. Second, which means he has to work only in India and only for the government of India. Second, he cannot, if he leaves during the tenure of his service contract, which I think is 3 years or 4 years, between one of the three, he has to pay 3 crores to this Oceanic Institute, which is there in Goa, right? Now that is allowed. He actually called and he said, yeah, he calls me Dada. All of this is there. Do you think they can do all this? I went through it, and he is in a very, very, very specific industry, right? He's in a very specific industry, is that of geology, which deals with climate change and climatology and glaciers and all of that. He is in a very specific position. He is a scientist working working between the Norwegian government and the Indian government and doing a research project, right? Which is going for 3 years. And there is a select situation because the agency from the Indian government side is also sponsoring his PhD program with the Norwegian university, right? So in combination of all these three, it will definitely pass the test of reasonableness and the test of fairness. So it has to pass this, and only then there can be an exception. Otherwise it's not possible. So as a best practice, what is it that we should do? Right? Very important is that 99 times out of 100 you cannot enforce a non-compete after employment. 99, I can say 99.5 times out of 100. So at least during employment, if you want to enforce, you need to have it right in your HR policies. So on your offer letter, on your appointment order, as well as on your HR policy, define non-compete. Define what do you mean by non-compete, right? It's not that they cannot go and join another competitor. That is one of the possibilities of non-compete. There are 100 other possibilities. Define office of profit. Today, if you are going to have restrictions on office of profit, people will just do stuff without your knowledge as employers, right? They will still continue to be the LIC agent. They'll just not tell you. They'll still continue to be, MLM agents. They'll just not tell you. They'll still go to speaking engagements. They'll have their own YouTube channel, like how I have. They'll be independent directors on boards of other companies and get a director sitting fee. All this I do, so I know. But then what is important is that have a process. Don't restrict. Have a process. I think we are in a world where we need to understand that you cannot restrict everybody and everything. Right? So define that process. Okay, if you want to go speak somewhere else, and if that is the case, then you come to me, you get our consent, right? If you're going to share something which actually belongs to the company, or if you're going to talk about best practices of your employer at even if it is at a college, it's okay, but just get consent, just get permission that you're sharing all of this. Right? So whatever it is, have a HR policy, because if you don't have a HR policy and if your employees are not aware of it, there's just no point in having a policy and employees not being aware of it. Non-compete post-employment clause is absolutely invalid. So forget about it. And test reasonableness of any restrictive clauses. Right? I'm not only talking about non-compete, even reasonableness of any other restrictive clauses. Like, for example, there are we also advise companies on legalities and all of that. So there was one company which said, in fact, one CEO who said, we invest so much in training our people, and they are freshers just out of college, and if they leave within 1 year, I want them to pay back the company 10 lakh rupees. Is that reasonable? It is not. So it won't hold good. Will you be successful in creating a fear in the minds of the employees? Yes, you will be successful in creating a fear, because the employee doesn't know whether it is reasonableness or not, right? Because they are not attending our webinars. but then if it goes to court, right, it won't pass the test of reasonableness, because it has to be in relationship to fairness. It's not about affordability. It has to be reasonable and it has to be fair. So any restrictive clauses to that extent. Recently I was reviewing a legal document for one of the companies, and I saw the employee has to give 90 days of notice period to the employer. Okay. But the employer can give 15 days of notice period to the employee. Is this fair? It's not fair. It has to be mutual. Worst come worst, at least the gap has to be less. If you expect your employee to give 90 days of notice, you are also expected to give employee 90 days notice. If you expect your employee to give 30 days notice, you are also expected to give your employee 30 days notice. That's fairness. You cannot have contracts which are one-sided. If they fail the test of reasonableness and the test of fairness, everything will go into doldrums, including your company's reputation. The brand, the equity, the reputation, which is so very vital in today's business environment. Everything goes for a six. So just make sure that there is reasonableness in your restrictive clauses. Before we open up for questions, please, you can start putting up your questions on chat box. Quickly, some facts about us for those who are new. We are 13 years and young. We are 153 clients and counting. We do about 1.2 million transactions a quarter. Our accuracy rates are 99.5. We are available at 16 cities in India, and are and we take great pride in saying 4.5 lakh Form 16s have been issued by us. We are in the business of payroll, taxation, compliance, and accounting, and we are so proudly there. Right? This is what we do, and now time for Q&A. So while you see all this, we are there on LinkedIn. We have a YouTube channel. As we speak, my team is putting up the links. Please feel free to visit, connect, and have it. Okay. So yes, I think I got the first question. Rajesh, Shruti, Navina, thank you to you too. Kanksha asks a question not related to the topic. If someone has served notice period, their FNF is done, nothing pending, can they send a legal employer to ex-employer for not sharing experience letter? Is that this is a last resort after multiple follow, though more than a year, and escalated to CEO and founder? Can they send a legal notice to that ex-employer for not sharing experience letter? This is a last resort after multiple follow-up through more than a year and escalated to CEO and founder. So if you feel that you have not been treated fairly, right? Like, for example, they have been giving experience letter to everybody else, but they have not given it to you. You can definitely send a legal notice, because in that case, there is this test of fairness that they cannot look at you differently until and unless there is sufficient cause or evidence. So that we can definitely do. It is possible. Okay. Thank you, Sushil. Thank you, Usha. Okay, we have a poll coming up. So guys, take a quick few seconds for our poll as well. That will really help us do better the next time. It will also help my team organize more of these sessions. So the poll coming up right now, launched. Yes, just a couple of seconds, please. Take a couple of seconds for your session. Okay. Best wishes to Relativity. Thank you. Okay, Margaret asks, how can we know if an employee is working for two employers? Is there any way we can find out? Any portal? No, I don't think there is any portal or any way that you can find out. Maybe you can find out through Provident Fund EPFO portal, but that also only if that employer is a PF paying member, and then this employee is enrolled in the Provident Fund and all of that. So there is no straight way to do that. Next is, thank you, Akanksha. Once employee, okay, Ajay asks, once employee leaves and joins competitor, then he is having some confidential info of the company, which might be harmful to last employer if he is using a competitor. Then such non-compete agreement will work or not? So here you actually cannot enforce a non-compete agreement. Rather, you need to enforce a non-disclosure or a confidentiality agreement. So the question, Ajay, is, do you have a don't tell me you have it as one of the clause in the offer letter or appointment order. It doesn't work. If there is a specific confidentiality agreement or a non-disclosure agreement as a part of the employee's contracts with the employer, if that is so, and if in your confidentiality agreement there will be description of information which is considered confidential, if that information, if that description covers this confidential information that you're talking about, then there is a possibility that you can actually enforce, but not a non-compete agreement. Not a non-compete agreement. Yes, can an employer hold an employee's salary when they abscond? So what are your terms and conditions? 1+ LE 2101. 1+, huh? How come 1+ can ask questions? I know 1 plus is maybe a gentleman or a gentle lady. So the way of how you cannot actually hold an employee's salary. What you can do is, see, when you say abscond, I understand that they wouldn't have served the notice period and then they would have just left, right? What happens if you don't, if you sack the employee, you are supposed to give them, let's say your notice period is 30 days. You are supposed to pay them for those 30 days, right? So the same way, if there is a clause in your offer letter or the appointment order, which says either party will either give 30 days notice or payment, gross salary in lieu thereof. If this clause is mentioned, then what you can do is you can calculate their full and final settlement, saying, okay, this is the salary that we were supposed to pay you as on this date, and this is the salary that you are supposed to pay us because you did not serve the 30 days notice or 15 days notice or whatever balance. So 30,000 I'm supposed to pay you. You are supposed to pay me back 35,000 minus 5,000, which means you have to pay me 5,000 is what you can definitely say. So that is how you do the calculation. You really cannot hold an employee's salary. That's not possible. Okay. Few more. I hope that answered your question. What is the YouTube channel name, Sumalata? There is yeah, you can see your okay. Jiteshwar, thank you to you too. Okay, Ajay. Okay, Saurabh Chauhan asks, one employee working with us on two years agreement, 2 years agreement will have a one employee was working with us on a 2 years agreement. We have a clause. If he completes 2 years, he will get 2 lakhs retention amount. If not, then he have to pay 2 lakhs amount to the company. Now, employee left the organization even without notice period. What action can we take as an employer? So you can definitely recover if you have all the paperwork right. You can definitely recover the 2 lakhs that you have mentioned in your contract. Plus, you can also recover the value for the notice period if that is also mentioned in your contract, which is your offer letter as well as the appointment order. So both of this can be done. But of course, you see, I don't want to sound rhetorical, right? Many times it is best to sort it out with amicable means than to resort to legal situations, but there are some situations which only warrant a legal approach. If that is the case, then it's fine. What are the gag clauses and how does it differ from non-compete or non-disclosure agreement? I'm sorry, Rajesh, I did not understand this gag clauses. What do you mean by gag clauses? If you can just throw some light on it, it'll be helpful. See, in generality, right? Non-compete is restricting your ability to do a business, trade, profession, something like that. That is what is non-compete. Non-disclosure is more than non-compete, right? Non-disclosure is you have knowledge of information which is important to our company. You should not disclose that outside, is what a non-disclosure agreement means. It need not necessarily be to competitors. It can even be on a public forum. You should not disclose it on a public forum. Who are my key clients? That is governed in the non-disclosure agreement. You cannot disclose on a public forum what are the security vulnerabilities of this software which you have been a part of when you have developed. That is a non-disclosure agreement, right? You get the difference. Non-compete is about practice of a profession, trade, or business. Non-disclosure is specifically to information. Notice period applicable in provision period. What? Notice period applicable in provision period or not? applicable in provision period or not? I mean, I'm sorry, Praveen. Can you be a little more specific with your question? Is there any? Oh, sorry. Yeah, Sindhu asks, is there any particular deadline time frame on giving warning letters? One of the HR asked me this question in an interview. Yes, there is, because see, when do you give a warning letter? There is no, see, there is no law, but there is definitely a best practice, right? Let's say the employee has committed an act which requires you to provide a warning letter. The best practice is to issue that within 7 to 14 days. There is no point in issuing warning letter after 6 months, Sindhu, right? It doesn't make any sense, because the employee is not aware that his or her actions are outside of what the employer expects. So 7 to 14 days is the time frame. Within, it's a best practice. There is no law again, for giving a warning letter, but it's 7 to 14 days best practice. Parimala says, oh yeah, sure. Thank you for attending. One plus, can an internal team of an organization draft these policies, or should it be under any legal authorities? See, all of these are, they have to be drafted by legal, right? By a legal team, either a counsel or an advocate or a lawyer, one of these three people. It could be your own counsel, in-house counsel, if you are a large organization, or you have to take services. See, you cannot do everything, right? We don't have the expertise to do everything. But when you are doing it, please don't go to Google and search and find the cheapest online service provider, or copy it from download a template from site HR and make the changes. No, that really won't help as well, because that is generic. What you need is something specific, drafted for your company, for your situation, for that particular employee or whatever. And for you to protect your business, it costs money that you have to pay to these lawyers, advocates, or counsels like us. You just have to do it. There's no other choice, right? Go to a good one. Okay, go to a good one. Sanjana, thanks, Akash. Your energy this morning was wonderful. Thank you very much, Sanjana, for the kind words. Margaret, thank you. Rajesh, somewhere I got to read gag clauses are restrictive clauses to maintain confidentiality about company practices, processes. You can definitely have a confidentiality agreement, Rajesh, but you cannot say, okay, software development, the what is that cycle? The employee life cycle, hire to retire, is unique to my company, so you cannot go and talk about this hire to retire in another company, because this is not unique, right? So even when you talk about company practices or processes, there has to be substance for confidentiality. If there is no substance for confidentiality, still we can't probation. I think he's saying probation. Okay, I think that question came up earlier. Notice period on probation, is it? So there is notice period on probation also, as long as you spell it out on the offer letter. There is a requirement for notice period everywhere. See, earlier you had, what is probation? Let's try and understand that. Probation is a time, right? 3 months or 6 months, where you are testing the performance of the employee, and the employee is testing his or her ability to work with you. It's probation is both sides. So what is important is it has to be spelled out. Once it is spelled out in the offer letter, but again, it has to be both sides. You cannot say the employee is supposed to give you 30 days notice in probation, but you will sack him whenever you want. That can't be said. Yeah. And just a quick reminder, guys, about the polls. I think, okay, good. 100% have participated. Very, very good. Thank you. Going back to, where did the chat go? Yes, it's here. Okay, is notice period applicable for probation period or not? Yes, it is applicable for probation period as well. Please have it mentioned in the offer letter or appointment order. It can be 2 weeks, both parties. It can be 2 weeks, it can be 1 week, it can be 30 days. But both parties, fairness, and it has to be mentioned, it has to be written down. Jyotirmay. Oh, yeah, you are the one plus. Thank you very much, Jyotirmay. Is there any certain time period to complete FNF of the employee? Fairness again, until the new labor code requires you to complete in 2 days, but right now the best practice is between 15 to 30 days. Right, but the new labor code requires you to complete in 2 days. That's a test. That's a certain test. Can an employer deduct a PF on behalf of employer as well for the employee? Where? Okay, so if you have a CTC based structure, then you agree with the employee that the total cost to the company, let's say, is going to be 50 lakhs or 15 lakhs. And then your employer PF, employee PF, employer, everything is deducted from that 15 lakhs only. But if you have a gross based structure, then it is the employer who has to contribute the additional value. Okay, topics, HR. I'm working in one company. They have kept my salary hold from June 20 to December 20. They're all committed to give. Still, I'm working in the same company. They are releasing my current salary. Where they are saying we will do after, but I cannot able to believe. What should I do now? Quite a difficult question to answer. What do you want to do? Right, that's the real question. You're still working for that company, which means you really like the environment, or for some reason you are still continuing to work there. So do you really want to take legal action? Then maybe your current employment will be at risk, or your current relationships that you have with your company will be at risk. So the real question is, what do you want to do? That's the real question. How is it practically feasible for the current employer to act on behalf of employee for breaching NDA and CA? Practically feasible for current employer to act on behalf of employee. Trust me, Rajesh, you will know when there has been such an important and critical breach. If there has been one, you will definitely know, right? Companies, employers, or rather businesses, they are, and particularly services or manufacturing, a lot of knowledge, 80% of knowledge is not specific to that company. It cannot be classified as confidential information at all, but there is 20% which can be classified as confidential information, and somebody will benefit out of it, right? So you will get to know that. So it is feasible for breaching. Let's say if you're asking me, does it really help to approach the court? Yes, it really helps to approach the court. Sometimes we need to approach just to make an example. Sometimes we need to approach because there is a serious consequence in terms of loss, either loss of name, loss of brand, loss of profit, loss of revenue, something. So if there warrants a compensation, then that has to take. Thank you, Priyanka. Can I take legal action? I'm still active in the company. Topics HR. I think you should definitely talk to probably a lawyer. They may be able to help, because it also requires a lot more questions that that this forum may not be the right forum to ask. Wonderful. Thank you so much, everyone. I try to keep it. I try to maintain the 60 minutes, but sometimes there are just questions and I hate to leave. So with all of you and your energy, this morning has been outstandingly great. Thank you so much. And we look forward to meeting you again the next Wednesday. The second Wednesday of the next month. Until then, ciao, tata, bye-bye. See you in the next one.